Welcome to Rights and Reforms, the podcast where we explore the evolving relationship between constitutional rights and the American public. We're your hosts, Hannah,
Mozzie, and Jada.
And today we're diving deep into some of the most significant amendments, Supreme Court cases, and modern-day debates that shape how we live our lives. From religious freedoms and privacy rights to balancing national security with personal liberty, we'll unravel the complex tensions between individual rights and societal needs. Join us as we take a closer look at how these legal principles are tested in our courts and how they continue to influence the very fabric of our democracy. Let's talk about the right to privacy. This concept isn't explicitly stated in the Constitution, but it's often said to be implied, especially within the framework of the Bill of Rights. As we get into the First Amendment, it's important to understand these clauses, the Establishment Clause and the Free Exercise Clause. The Establishment Clause establishes separation of church and state, meaning that you can't essentially have a Church of the United States, but you can have their own denominations, while the Free Exercise Clause protects rights to practice religion freely. Some Supreme Court cases that display where the Establishment Clause and Free Exercise Clause were demonstrated were the Engel versus Vitale case. This was against state-sponsored prayer in public schools. While the Wisconsin versus Yoder, individual rights to free exercise of religion outweighed states' interest in making kids go to school past 8th grade. Through freedom of religion and public policy, the government tries to find a balance between states' rights and individual rights when it comes to the free practice of religion. And now, in more modern debates, especially after Dobbs v. Jackson Women's Health Organization decision overturning Roe v. Wade, reproductive rights have come to the forefront. Many argue that a woman's right to choose on abortion is deeply connected to her privacy. And with the further development of social media apps like Facebook, Instagram, and TikTok, privacy concerns are bigger than ever. The question is, how do we protect our personal information in a world where everything is connected? And as we move from the principles of religious freedom to the realm of privacy rights, let's examine how the Constitution indirectly protects personal freedoms, even in the absence of explicit mention. In the next segment, we'll delve into how the rights to privacy have shaped major court rulings and sparked modern debates. As these amendments balance individual freedom with public order safety, it can be tricky. And limiting individual freedoms are sometimes necessary in order to maintain public safety. For example, the Patriot Act. It allows the government to investigate citizens in order to ensure public safety. The Patriot Act was passed after 9/11, giving the government more power to monitor citizens' communications and financial transactions in the name of national security. In the following court case, Schenck versus the United States limited freedom of speech during wartime efforts. Following on Schenck versus the United States, the court ruled that during wartime, the government could limit free speech if it posed a clear and present danger. This shows that when national security is at stake, individual freedoms can be curtailed. Now, while privacy rights focus on what's personal and protected, there are moments when public order and safety must take precedence. We'll explore the balance between individual freedoms and the government's role in ensuring national security, with landmark cases illustrating the ongoing debate.
Social movements have played a major role in reshaping our understanding of equal protection under the law. In this next section, we'll examine how social movements like the civil rights and LGBTQ+ movements have influenced landmark Supreme Court decisions and advanced civil rights for marginalized groups. For examples, in the case of the civil rights movement, the Civil Rights Act of 1964 led to the end of Jim Crow laws, and in the case of the LGBTQ+ rights movement, cases like Lawrence v. Texas, which legalized consensual relationships between couples of same sex. Social movements played an important role in influencing legislation such as the Supreme Court cases mentioned, and these cases challenged the separate but equal ruling that had been the precedent in previous years. Of course, movements and legislation don't always go hand in hand with government support. Let's take a look at how government responses have evolved in the face of societal change and discuss the effectiveness of key policies that have helped move the nation towards greater equality. One example of the government supporting civil rights legislation would be the Voting Rights Act, which led to a higher percentage of African Americans voting in the South and participating in politics as a whole. On the other hand, in landmark cases like Roe v. Wade, which was later overturned, was an example of how the definition of civil liberties and individual rights has changed and evolved over time.
But how do we protect these rights of minorities in a democratic system where the majority rules? In this segment, we'll explore the 14th Amendment has used to ensure equal protection, and we'll consider how modern debates like gerrymandering and affirmative action continue to challenge this balance. 14th Amendment is the equal protection under the law for all. In other terms, the 14th Amendment ensures that everyone has equal protection under the law, regardless of race, gender, and religion. We can see the 14th Amendment being used in certain cases, such as Brown versus Board of Education, which makes sure that minority rights are not being crossed. State-sanctioned segregation of public schools was a violation of the 14th Amendment and was therefore unconstitutional. This is a great example of a case protecting minority rights because it ensures that no one is being discriminated against due to color, gender, religion, and more. However, there are still some debates surrounding majority rule and minority rights, which are commonly complex, especially when it comes to voting and affirmation action. Discussions often revolve around the balance between democratic principles and the protection of individual and group rights. Now we will be taking a deeper look at the history of affirmative action, its purpose in creating equal education opportunities, and how the Supreme Court has weighed in on its fairness in recent years. So essentially, affirmative action is taking positive steps to give an end to discrimination against minorities while providing new opportunities that were previously denied. Some examples of affirmative action being taken place are commonly court cases, such as University of California versus Bake, which ruled that race is a factor in college admissions, but institutions are not required to have a certain quota. Some examples of affirmative action being used are commonly in court cases, such as University of California versus Bake, which ruled that race is a factor in college admissions, but institutions are not required to have a specific quota. Examples of affirmative actions are commonly used in court cases, such as Grutter versus Bollinger, which essentially ruled that race can be considered in college admissions, but cannot be the main factor. Grutter versus Bollinger is a case that involved two females, Jennifer Grutz and Patrick Hamter. Two of the girls both applied for the University of Michigan, and even though they were qualified, they were still denied for not being competitive enough. They argued that because of their race and ethnic group, they were denied, claiming that it violated the equal because they argued that because of their race and ethnic group, they were denied, claiming that it violated the Equal Protection Clause of the 14th Amendment and Title V1 of the Civil Rights Act of 1964. However, the court did not appeal to this affirmative action, and they made it constitutional for colleges to consider race, but again, not make race a reason as to why an individual gets accepted into colleges. And that brings us to the end of today's episode of Rights and Reforms. We've covered a lot of ground, from the complexities of individual freedoms to the role of social movements in shaping our legal landscape. The balance between public order, national security, and personal liberty continues to evolve. But one thing is clear: these issues are as relevant as ever in the fight for justice. Thanks for joining us, and we hope you'll tune in next time as we continue exploring the intersection of law, society, and civil rights. Until then, stay informed, stay engaged, and keep questioning the world around you.